Welcome back to AI Serendipity, where tradition meets innovation and we always ask the hard questions. I am Santiago Martín Caravaca, an Italian-Spanish dual qualified tech and IP lawyer, a technologist by curiosity, and your guide to the twists and turns of the Suno AI case. In today's episode, we are going to focus on Suno's affirmative defenses. We'll explore each defense from the classic seal of fair use to the bold claim of copyright misuse, and how they stack up against the plaintiff's allegations. Let's jump right in. What are affirmative defenses? Let's start with basics. What exactly is an affirmative defense? In essence, it is a legal strategy where the defendant acknowledges that the plaintiff's allegations may have some basis in fact, but argues that those facts, when viewed through the right legal lens, don't result in liability. Think of it as Suno saying, even if the plaintiff's claims are true, here's a legal reason why we are not liable. For each of these defenses, Suno has the burden of the proof. This means that Suno must present evidence to convince the court that the defense is valid. For example, if they argue fair use, they must show why their use of the plaintiff's recordings meets the legal criteria for fair use. Here's the important part. Suno doesn't have to pick a single approach. They can deny the plaintiff's allegation entirely, saying, we didn't do it, while simultaneously using affirmative defenses to say, but even if we did, here's why it wasn't illegal. Think of it like playing chess. Suno isn't just defending against the plaintiff's current moves, denying the allegations. They are also planning multiple counter moves, affirmative defenses, to prepare for what the plaintiffs might argue next. This layered strategy allows Suno to stay flexible, adapt as the case develops, and attack the plaintiffs from several angles. It is about having as many tools and tactics as possible to win the case. Suno's approach isn't just defensive, it is proactive, and it starts with one of the most well-known arguments in copyright law: fair use. Fair use is the foundation of copyright exceptions, and Suno is relying on it heavily in their defense. According to Section 107 of Title 17 of the United States Code, fair use allows limited use of copyrighted materials for specific purposes, such as commentary, criticism, and research. Now, the big question is, how does Suno argue that their use of the plaintiff's recordings fits into this legal exception? Transformation. Suno claims their AI doesn't simply copy the plaintiff's recordings. It analyzes them to extract statistical insights. These insights are then used to generate entirely new, original music that doesn't replicate the original works. This transformative nature is a critical factor in fair use analysis. Focus on innovation. Suno positions itself as a facilitator of creativity and innovation. While they charge for their services, they argue that their purpose isn't to reproduce or resell copyrighted works, but to enable new artistic expression. Minimal market harm. Suno asserts that their AI's outputs aren't substitutes of the original recording, meaning they haven't caused economic harm to the plaintiffs. The second affirmative defense, copyright misuse and unclean hands. Now, this is where things heat up. Suno accuses the plaintiffs of copyright misuse and operating with unclean hands. Essentially, Suno is turning the tables, arguing that the plaintiffs themselves are not playing fair. Here's what they claim: violated antitrust laws. Are the plaintiffs trying to stifle competition by overextending the copyright claims? Suno seems to think so. The plaintiffs may be accused of leveraging copyright law to control areas it wasn't meant to cover. Copyright is supposed to balance creator protection with public benefit. If plaintiffs are using their rights to suppress innovation, that balance is tipped. Think of it this way: if you use a rule not to protect your rights but to prevent others from playing the game, the court might find such conduct inequitable or abusive. The third affirmative defense, equitable doctrines. Next up, waiver, stoppel, and laches. These are fancy legal terms, but they boil down to fairness and timing. Waiver means the plaintiffs may have voluntarily or implicitly given up their rights through their words or actions. Stoppel prevents plaintiffs from asserting rights if their past actions were inconsistent with those rights, especially if Suno relied on those actions to its detriment. Laches is about fairness and timing. If the plaintiffs waited too long to sue, Suno could argue it is unfair to penalize us now, especially if the delay caused harm to our position. Affirmative defense. Suno claims the use was licensed, explicitly or implicitly. An explicit license means that maybe there is a contract or an agreement we don't know about yet, explicitly allowing Suno to use the works. Perhaps this is something that will come to light during discovery. Implied license, sometimes the way a copyright owner behaves implies permission. For instance, if someone makes their works widely available under circumstances suggesting public use, it could create an implied license. Suno is essentially saying, if you gave us the green light explicitly or through your actions, you can claim infringement now. Additional defenses: public domain, de minimis use, and more. Let's quickly touch on some of Suno's other defenses. Public domain. Suno hints that some of the material plaintiffs are claiming might be in the public domain. What does that mean? Public domain works are free for anyone to use. Think of Beethoven's symphonies. If plaintiffs are trying to enforce rights over works that no longer have copyright protection, Suno is effectively saying, not so fast. You can sue us for using something everyone has a right to use. Suno is plenty in doubt about the scope of the plaintiff's ownership and forcing them to prove the rights over each individual work. De minimis use. The term comes from the Latin phrase de minimis non curat lex, which means the law doesn't concern itself with trifles. Suno is saying, even if we copied something, it was so minor that it shouldn't count as an infringement. How minor are we talking? A single chord progression in a song, a strategically placed silence in a musical composition, a few milliseconds of a recording used in an AI training process. Courts have ruled in past cases that small, unrecognizable uses don't constitute infringement. For example, a 3-note sequence because it was deemed insignificant. Suno's strategy here is clear argued that any copying was so trivial it shouldn't even be on the legal radar. Innocent infringement sounds almost poetic, doesn't it? But it is a serious legal argument. Under Section 504, subsection C, paragraph 2 of Title 17 of the United States Code, if a defendant proves they didn't know and had no reason to know that the actions were infringing, the court can reduce statutory damages to as low as $200 per work. Suno's implication here is that if there was infringement, it wasn't intentional. Perhaps they are saying the data was ingested unknowingly during the AI training process, or that they relied on third-party sources who claim the material was free to use. Why this matters? Innocent infringement doesn't erase liability, but it drastically reduces financial exposure. It is like admitting you made a mistake, but arguing it was an honest one. 8. Affirmative defense. The 8 defense is a classic. Copyright infringement claims must generally be brought within 3 years after the claim occurred under Section 507, subsection B of Title 17 of the United States Code. Suno appears to argue that the plaintiffs are suing for action that fall outside this 3-year window. If Suno can prove this, the defense might limit the plaintiff's claim to more recent action or even knock out portions of the case entirely, depending on whether the court applies the discovery rule or considers the alleged infringement to be ongoing. 9th affirmative defense, no probable injury. Finally, Suno argues that the plaintiffs have suffered no probable injury. Essentially, they are saying, even if we did use your works, you can show that it harmed you. This challenge a key element of some copyright claims, proving a direct link between the defendant's action and economic reputational harm. For example, if the plaintiffs can't demonstrate that Suno's AI model reduced their sales or market value, their ability to claim damages based on actual harm becomes much weaker. However, even without evidence of probable economic harm, plaintiffs might still pursue statutory damages under copyright law. Obtaining injunctive relief, however, would require plaintiffs to demonstrate irreparable harm, making this defense a significant challenge to the case. Suno's 10th affirmative defense takes a direct shot at the plaintiff's request for both preliminary and permanent injunctive relief. Let's unpack what the plaintiffs are asking for and why Suno is challenging it. The plaintiffs are asking the court to essentially shut down Suno's operations, an injunction that would require Suno and everyone associated with them to stop any activities that allegedly infringe or even contribute to infringement of the copyrighted works. But here's the catch. Injunctions aren't granted lightly. Under US law, the plaintiffs must meet several strict legal standards to secure this type of extraordinary relief. For instance, irreparable harm. They must show that legal remedies like financial compensation simply won't address the damage caused. Injunctions must align with broader public policy, ensuring they don't harm the public more than they help. Suno's argument, the plaintiffs haven't met these criteria. They contend that any alleged harm can be adequately compensated with monetary damages, which negates the need for such sweeping relief. Suno is pushing back against the plaintiffs' narrative, arguing that shutting down their operation would be both unnecessary and disproportionate. 12th affirmative defense, attacking the validity of copyright registrations. Under Section 411, subsection A of Title 17 of the United States Code, a valid registration is generally a prerequisite of filing a copyright infringement lawsuit in federal court. A registration is defective, the plaintiff's case could falter, essentially saying, "We have serious doubts about the validity of these registrations. Prove they are valid." This defense opens a crucial line of attack. Suno might argue, for example, that the works were improperly registered or failed to meet statutory standards, that the registration don't align with the specific works allegedly infringed, or that errors or omissions in the registration undermine the plaintiff's ability to rely on it in this case. Additional affirmative defenses. They've reserved the right to assert additional defenses as the case progresses. What does this mean? During discovery, the phase where both sides gather and exchange evidence, unexpected details often come to light. By explicitly stating that they haven't knowingly waived any defenses, Suno is keeping their options open to adapt their arguments based on new evidence. This is more than just a procedural formality. It is a sign of strategic foresight. Litigation is unpredictable, and flexibility is a powerful asset. By reserving the right to amend their answer or assert additional defenses, Suno is signaling that they are ready to pivot as the case unfolds. Indeed, litigation is as much about the strategy as it is about law. Suno showcased their tactical precision. They are forcing the plaintiffs to fight on multiple fronts. It is a bold, calculated approach, and one we'll be watching closely. If this episode sparked your curiosity or left you questioning, don't just listen, subscribe. Join us here at AI Serendipity. Next time on AI Serendipity, we'll dive into the core of Suno's request for relief. We'll dissect their bold ask for a judgment in their favor, the strategic push for a dismissal with prejudice, and the calculated move to shift the financial burden of litigation onto the plaintiffs. Until then, keep questioning, keep asking the hard questions, and remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.